Hello, everyone. I'm Andrew McKenzie. I'm one of the partners here at Beresford Booth, and I practice in real estate and litigation. Today, we're going to be talking about a really great topic in real estate, which is discovering easements on your property. A lot of people, when they learn what an easement is, they are curious whether there might be an easement that burdens their property. Before I delve in, I do want to make sure that the audience knows we do have a YouTube channel. And we would appreciate if you can search Beresford Booth in YouTube and like our channel and subscribe. And I'm going to delve in now by sharing my screen. There we go. Okay, does your property have an easement on it? How to find out? So we first need to discuss what easements are. An easement is a property right separate from ownership that allows the use of another's land without compensation. I've seen situations where people were beneficiaries of an easement and they thought that that meant that they owned the land. That is not the case. An easement is the right to use somebody else's land, and in almost all cases, that is a concurrent use, not an exclusive use. There are rare exceptions to that rule. Most of the time, easements are for ingress, egress, and utilities, but sometimes they can be for other purposes like landscaping, or sometimes there might be a structure that was accidentally built over the property line. There might be an easement in place to resolve that issue and resolve the encroachment. Generally, an easement needs to be recorded in the public records in order to be binding on subsequent purchasers and third parties. But there are exceptions to that rule. There are different ways to create an easement. The most common way that an easement gets created is through an express grant or reservation. We're talking about a writing, and we're going to go into an example of what a writing like that actually looks like. But there are other ways to create an easement too by operation of law. And one of those ways is an easement by prescription, which is similar to adverse possession, but instead of acquiring ownership of property, you are merely acquiring an easement. In other words, the right to use somebody else's property. Once you've acquired that prescriptive easement, the owner of the property that it burdens cannot kick you off or block you, generally speaking. There are other methods of creating easements, which we will talk about briefly later on. This here is an example of what an easement looks like when it gets recorded in the public records. This was recorded decades ago, so this document is not the most modern looking, but you can see that the title of the document is Grant of Easement. And here it's signed by the grantors. It's got a notary stamp. But it's a common pitfall for people to assume, and I've even seen attorneys make this assumption, that any easement recorded in the public documents must have the word easement in its title, and that could not be further from the truth. There are dire consequences that can follow from not realizing that your easement, that your property has an easement on it, or that somebody else's property has an easement on it. One of those is possible litigation between landowners. Another is when you buy property and you don't realize that it has an easement on it, it can screw up your plans or expectations for what you were going to do with the property. Maybe you were going to build a house on it, but you didn't realize that the spot that would be the perfect building pad for the house on this property has an ingress and egress easement for the neighbor running right through the spot you were planning on building. So it is critical, particularly in the context of vacant land and prospective development of land, that you research carefully to see whether property may be encumbered by an easement. Some people believe that when there's an easement that somebody didn't know about it, that automatically means that a title insurance company is liable. That is not always the case. It's very frequently not the case. So you should not make that assumption, and that would be an issue that would be good to consult an attorney about. In the context of real estate brokers and managing brokers, when you are involved in a real estate transaction, it's important to know that your client could be potentially liable for not disclosing an easement that they know about. And that if you're representing a buyer, they could be very disappointed that an easement was not discovered. Sometimes easements are discovered during a due diligence phase or after contingencies have been waived, and that can create a dispute between a buyer and seller over earnest money and whether or not it's refundable. So it's important to do your due diligence early on and discover early on whether or not the property that you are looking at acquiring may be encumbered by an easement. I'm going to give a brief case study about a case in which I represented one of the neighbors in a dispute over a shared driveway. In this picture, we can see two houses that are on either side of a very narrow driveway. The house on the left was my client's house, and the house on the right owned the property over which the driveway runs. So the property boundary between these two properties is approximately immediately to the left of this shared driveway that you see in the picture. The dispute happened in large part because the property owner on the right did some searching, and they mistakenly thought that when they were going through the county records, they needed to find a document that said that was called easement. And because they were using the wrong criteria to determine whether there was an easement encumbering their property, they erroneously concluded that there was no driveway easement in favor of the property owner on the left. And that resulted in years-long expensive litigation that could and should have easily been avoided. So here is one of the documents that was involved in the case that I just mentioned down in Burbank, California. This is the grant deed that gave title to my former clients, the owners of the house on the left. And you can see it's not called easement deed, it's not called grant of easement, it's just called grant deed. But here, if you look on the next page, there in parcel 2 is a description of an ingress and egress easement right there. So you need to know what you might be looking for. You need to appreciate that when you're going through recorded documents, you may need to examine the actual content of the documents and not just the title to see what rights are being imparted. There are several methods to go about trying to discover whether property may be encumbered by an easement. The most common method, or I suppose most intuitive method, would be actually searching the public records themselves. Fortunately, in Washington State, the majority of counties do have online public records that are searchable by the public without a fee. So that is great. However, those databases do not go back to the beginning of time. And sometimes you're only able to go back a few decades, but before that, everything is only in the form of physical copies that you have to go down to the recorder's office or auditor's office to physically inspect. Another way of going about discovering whether property is encumbered by an easement is title reports. We're going to be talking about that in a little bit more detail shortly. Also, having a survey performed can give clues as to whether an easement may exist. And we'll talk about other methods in just a little bit here. This here is a couple of screenshots from the King County Public Records portal. It shows you that you can search using several different parameters. You can search by name, you can search by document recording number, you can search by parcel ID number. Those are the most common ways of going about searching for recorded documents online here in Washington State. And most of the time you will have that information so that you can plug it in. Doing searches by legal description can be a little bit difficult. Sometimes the system can be a little bit finicky in terms of whether it likes the legal description that you have put in. So generally, if you've got a parcel number or a name, that's good. When you're doing searches of easements by name, you have to keep in mind that you will very likely need to search multiple names of all prior owners of the property. So if you see, for example, that there was a deed that 10 years ago conveyed the property from John to Joe, then you know that from 10 years ago and before, anything that was recorded before that is not going to show up as Joe being a grantor of an easement. You'll need to be searching under the prior owner's name and their prior owner before that, et cetera, et cetera. If an easement is granted outside of what we call the chain of title, in other words, it was granted by someone who did not own the property at the time, very likely would have no legal effect. There are limited exceptions to that principle. Here is an example of what an excerpt from a title report looks like. This is a title report issued by First American Title. And generally speaking, every title report that gets issued has a section in it that covers what we call exceptions. Those are items that the title insurance company is informing the prospective insured, usually a buyer, but sometimes a lender. They're informing that prospective insured that they will not be covering these issues. And that's typically where you are going to find, among other things, recorded easements listed in that list of exceptions in the title commitment or title report. So here, this is Schedule B, Part 2 exceptions. That's the section of the title commitment that you'll typically flip to see what areas may require further analysis or investigation. And here in this particular example, if you look a few pages into the list of exceptions, you can see that there are several recorded easements that are listed here. And usually the title company will give you a hyperlink within the title commitment that will allow you to just click on it and see the underlying document that they are accepting from coverage. So you can see that those hyperlinks are in blue here on these exceptions. So you'll need to look at the actual terms of those easement documents and see what portion of the property they may cover and see what their purposes are. Just because an easement covers a particular portion of a property does not mean that the beneficiary of the easement can use it for any possible purpose. Caution about using title reports. It's a common misperception among real estate brokers, buyers, lenders, and even attorneys. It's a common misperception that you can rely on a title report to tell you about all of the easements that burden a property. That, unfortunately, is not true. People oftentimes misunderstand the purpose of a title report. The purpose of a title report is to inform the prospective insured which matters will and will not be covered. That purpose means the title company is not necessarily going to list every single thing that they have found. And the title company is also not responsible for finding every possible thing. There may be coverage under the policy if they don't find it, but they do not owe a duty to their insured, generally speaking, to find every possible easement or encumbrance and list it in a title commitment. So the point is that title reports are not necessarily exhaustive. They are a starting point, usually a very good starting point. and I'd say a very high percentage of the time, they are going to share with you the information that you would want to know, or at least put you on the right track for learning that information. But you should not operate on the assumption that they are exhaustive. One of the reasons is that title companies generally only are searching public records. So in the instance where an easement has been created outside of the public record, that's not necessarily going to be something that the title company picks up and lists in their report. So you should be careful about putting too much reliance on a title policy. One often overlooked area of easement creation is the recordation of a plat map. Plat maps happen when an owner of a larger parcel wants to subdivide those into smaller parcels for development now or in the future. And they record with the county auditor's office a plat map that illustrates and describes all of the newly created lots. Typically, there are requirements that the newly created lots have deeded access to them because the county wants to make sure that if they're going to be developed, there aren't going to be legal problems with access. So they will typically require that a plat map at least describe and ideally also show where easements might be that will benefit newly created parcels. So we're going to look at an example of that. Here is a short plat in Cowlitz County from, it looks like 1976, so a long time ago. And if you look here, you can see these newly created parcels, lot 2, lot 3, lot 4, they all benefit from something that is written into the plat, 30-foot private road and utilities easement. So if someone were casually looking, trying to find an easement, they would not necessarily find this one by looking for a document called easement. They may have to examine the actual record and see that the plat map provides for that access easement. Another method for discovering potential easements is with a survey. And the reason I say that is twofold. First of all, surveyors, when they are creating a record of survey, they typically are going to draw from existing recorded documents to allow them to plot out on their drawing where known deeded easements exist on the property. That is oftentimes necessary for things like civil engineering. It may be important for site development and determining where a house can be put, where a driveway can be put, where a septic system can be put. In the ordinary course, if a surveyor's scope involves assisting with potential future site development, they're going to be looking at prior documents. And that can help you because it will not only reveal the existence of the easement, but it will also illustrate it so that you can see exactly where it is. It can be daunting for lay people and for attorneys who are not surveyors to read through a legal description in a document and try to figure out exactly where a described easement falls on a property. Sometimes surveyors or surveys will also reveal potential off-record easements that have been created by operation of law, such as where you have an encroachment type of a situation. Here is an example of an actual record of survey that was performed roughly 3 years ago. This is along the Skykomish River in Washington, and you can see here that the surveyor plotted out the boundary line between these two parcels, and there along the northern side of these parcels was an encroaching cabin that encroached from one property onto the other. Well, that work by the surveyor revealed this encroachment, and it would not be something that would typically be found by a title company when they are searching public records. Another thing to note on this example is that there's a gravel access road shown, illustrated here. That does not mean that there's necessarily an easement over there, but having that data from the surveyor can put on your radar screen the possibility that maybe in the past there was a prescriptive easement that may have ripened over time, or maybe there was some other kind of easement agreement that allowed for access beyond the public road that's on the southern edge of these two parcels. So surveys are generally a good idea, but they can also be expensive. And when you're in a typical modern residential subdivision, it's uncommon to have encroachments over the property line. So most people decide it's not worth their time and money to go through the hassle of getting a survey before they complete the purchase of their property. That doesn't mean it's not advisable, but in more rural situations like this, it's more common for property owners not to pay as careful attention of where their deeded property lines actually are. So moving on, there are other ways to go about determining whether there might be an easement on your property or the property that you might be buying. Walking the property and taking note of obvious conditions is an important part of this. It's a wise part of your due diligence. Sometimes you'll be walking along and you may realize, hey, wait a minute, it looks like somebody has established a driveway on my driveway and is using it to access the neighboring property. Or maybe someone has built a shed or some other structure that very likely encroaches. Those are things that are much better to sort out prior to a purchase than being lazy and relying on a title report only and discovering them to your horror later on. Sometimes in order to determine whether an easement has been established, you may have to dig into some history. The mere fact that there's a driveway that goes across your property to somebody else's property doesn't necessarily mean that there's an easement. That's an issue where it can be wise to consult an experienced real estate attorney as well to advise you. Sometimes they may not be able to give you a final opinion on the matter without gathering additional facts. I talked earlier about implied easements, which is one variety of easement that can be created by operation of law. Implied easements in Washington are generally of two kinds. There's an easement implied by prior use or an easement by necessity. In this case, we have in my drawing here an existing driveway over parcel 1 that leads to a house on parcel 2, and it comes from the public road there on the eastern side of my drawing. In order for there to be an implied easement, generally there needs to be unity of ownership, meaning parcel 1 and parcel 2 are owned by the same owner, and then one of those parcels gets sold off. Typically parcel 2 gets sold off, but without an express deeded easement over this existing driveway. In that circumstance, the law will typically imply that parcel 2 has an easement over the driveway on parcel 1 because it's against public policy to have landlocked property. It would not be fair, it would be highly inequitable for the common grantor who retains parcel 1 to say to the purchaser of parcel 2, sorry, you're now landlocked and you cannot access your house. You're now trespassing over my property. That's one of the reasons why we have this type of easement. It's to avoid that type of situation. Of course, the cleaner way to do it is to grant an express easement so that there's not any question or confusion. Some of the takeaways for this presentation, easements are not always easily found. That's because they're not always in the public record, and even when they are in the public record, they may be so old that you cannot easily find them online, or they may be buried in the content of a lengthy document. So you have to examine the contents to have a more accurate picture. Easements can have a major impact on your property rights, so it's important to know how to go about looking for them. It's also highly advisable to protect yourself with title insurance. It's not going to protect you against every possible risk, but it will greatly mitigate the possibility that there's something on your property recorded in the public records that you had no idea about. And that peace of mind can be huge when you are acquiring property. And last of all, keep in mind that this is a complicated topic. Easements and how they operate are complicated, and it is highly advisable to have a real estate professional on your team who is able to give you legal advice. And that's what we're here for at Beresford Booth. We hope that we will get an opportunity to work with you. Thank you.